Common law marriage, also known as sui juris marriage, informal marriage, or marriage by habit and repute, is a legal framework in a limited number of jurisdictions where a couple is legally considered married, without that couple having formally registered their relation as a civil or religious marriage. The original concept of a common law marriage is a marriage that is considered valid by both partners, but has not been formally recorded with a state or religious registry, or celebrated in a formal religious service. In effect, the act of the couple representing themselves to others as being married, and organizing their relation as if they were married, acts as the evidence that they are married. The term common law marriage has wide informal use, often to denote relations which are not legally recognized as common law marriages. The term common law marriage is often used colloquially or by the media to refer to cohabiting couples, regardless of any rights that these couples may have, which can create public confusion both in regard to the term and in regard to the rights of unmarried partners. Terminology, misuse of the term, and public misconceptions. The term common law marriage is often used incorrectly to describe various types of couple relationships, such as cohabitation, or other legally formalized relations. Although these interpersonal relationships are often called common law marriage, they differ from true common law marriage, in that they are not legally recognized as marriages, but are a parallel interpersonal status, known in most jurisdictions as domestic partnership, a registered partnership, conjugal union, civil union, etc. In Canada, for instance, while couples in marriage-like relationships may have many of the rights and responsibilities of a marriage, couples in such partnerships are not legally considered married, although they may be legally defined as unmarried spouses, and for many purposes they are treated as if they were married. In recent years, the term common law marriage has gained increased use as a generic term for all unmarried couples. However, this term has a narrow legal meaning. Studies in the UK have shown that the population has a very poor understanding of the legal concept of common law marriage. A 2008 poll in the UK showed that 51% of respondents believed, incorrectly, that cohabitants had the same rights as married couples. Non-marital relationship contracts are not necessarily recognized from one jurisdiction to another, and neither are de facto couples. Whereas common law marriages, being a legal marriage, are valid marriages worldwide. In the United States, common law marriage can be contracted in 9 states and the District of Columbia. People in these true common law marriages are considered legally married for all purposes and in all circumstances. A couple with a common law marriage should not be confused with a couple which cohabits without holding themselves as married spouses. Essential distinctions from statutory marriage. Common law and statutory marriage have the following characteristics in common. Both parties must freely consent to the marriage. Both parties must be of legal age to contract a marriage or have parental consent to marry. Neither party may be under a disability that prevents him or her from entering into a valid marriage, e.g., they must both be of sound mind, neither of them can be currently married, and some jurisdictions do not permit prisoners to marry. Otherwise, common law marriage differs from statutory marriage as follows. There is no marriage license issued by a government and no marriage certificate filed with a government. There is no formal ceremony to solemnize the marriage before witnesses. The parties must hold themselves out to the world as husband and wife. Most jurisdictions require the parties to be cohabiting at the time the common law marriage is formed. Some require cohabitation to last a certain length of time for the marriage to be valid, but cohabitation alone does not create a marriage. The parties must intend their relationship to be, and to be regarded as, a legally valid marriage. History. In ancient Greek and Roman civilization, marriages were private agreements between individuals and families. Community recognition of a marriage was largely what qualified it as a marriage. The state had only limited interests in assessing the legitimacy of marriages. Normally civil and religious officials took no part in marriage ceremonies, nor did they keep registries. There were several more or less formal ceremonies to choose from as well as informal arrangements. It was relatively common for couples to cohabit with no ceremony. Cohabiting for a moderate period of time was sufficient to make it a marriage. Cohabiting for the purpose of marriage carried with it no social stigma. In medieval Europe, marriage came under the jurisdiction of canon law, which recognized as a valid marriage one where the parties stated that they took one another as wife and husband, even in absence of any witnesses. The Catholic Church forbade clandestine marriage at the Fourth Lateran Council, which required all marriages to be announced in a church by a priest. The Council of Trent introduced more specific requirements, ruling that in the future a marriage would be valid only if witnessed by the pastor of the parish or the local ordinary, or by the delegate of one of said witnesses, the marriage being invalid otherwise, even if witnessed by a Catholic priest. The Tridentine canons did not bind the Protestants or the Eastern Orthodox, but clandestine marriage was impossible for the latter, since marriage required the presence of a priest for validity. England abolished clandestine or common law marriages in the Marriage Act 1753, requiring marriages to be performed by a priest of the Church of England unless the participants in the marriage were Jews or Quakers. The Act applied to Wales. The Act did not apply to Scotland because by the Acts of Union 1707 Scotland retained its own legal system. To get around the requirements of the Marriage Act, such as minimum age requirements, couples would go to Gretna Green, in southern Scotland, to get married under Scots law. Marriages by proverbe de praesenta, sometimes known as common law marriages, were an agreement to marry, rather than a marriage. The Marriage Act of 1753 also did not apply to Britain's overseas colonies of the time, so common law marriages continued to be recognized in the future United States and Canada. In the United States, common law marriage can still be contracted in Alabama, Colorado, Iowa, Kansas, Montana, Rhode Island, South Carolina, Texas, Utah, the District of Columbia, or under military law, except for same-sex interpersonal unions contracted by habit and repute. All jurisdictions recognize common law marriages that were validly contracted in the originating jurisdiction, because they are valid marriages in the jurisdiction where they were contracted. However, absent legal registration, notice of the marriage, parties may have difficulty proving their relationship to be marriage. Texas provides for registration of an informal marriage on the declaration of each of the spouses carried out on a state-provided form. Yet Louisiana, bordering Texas on the east, does not recognize Texas' formalization of an originally informal marriage despite the U.S. constitutional requirement. The other states recognize the Texas registration as certifying a valid marriage. All other European jurisdictions having long abolished marriage by habit and repute, Scotland became the last to do so in 2006.